My daughter was beaten. My daughter's hair was snatched out. My daughter was placed in a room naked without any clothing. She was taking off all of her medications. That following week was the court hearing. We got inside of his office. I recorded everything. Everything is recorded. How he pretty much flipped the script on me and said, I don't really know what to do, but we can get to court. He even stated that in the actual office, like he was confused. He flipped the script on me like I was a negligent parent. I didn't know what it was that I was doing as a parent. I said, are you turning on me now as my attorney? I was like, I'm an excellent parent. This is not about me being a horrible parent. I'm a good parent.
Day at that point, Ms. Lipscomb came into our office that morning around 9:30 and stayed until about 12:30. At that point, I had to let her know, listen, we got a hearing in an hour. We got to go. So we went to lunch. I showed up at the hearing, which was several hours long. Ms. Lipscomb alleges that I didn't know what I was doing. I was calling Ryan because I didn't know what was happening. The actual reason I was calling Ryan is because upon showing up at the hearing, Judge, there were a lot more issues than I was made aware of.
Welcome to the courtroom of Judge Donald Coleman, where a complex case involving the welfare of a special needs child unfolds. The plaintiff, a distraught mother, stands at odds with her former attorney. The mother alleges that the attorney failed to fulfill his obligations and was of little help, prompting her to seek assistance elsewhere. Now, seeking recompense, she demands a refund for what she deems as inadequate legal representation. On the other side stands the attorney, defending himself against these allegations. He argues his case, asserting that he fulfilled his duties and rendered appropriate legal counsel. As the courtroom proceedings commence, Judge Coleman faces a challenging task, discerning the truth from conflicting testimonies. The case boils down to a simple yet crucial question: who is telling the truth?
All right, this is case number 2324-0385. This is Felicia Lipscomb versus Clay Miller. Now, the matter is before the court on the filing of a petition to reopen this matter. All right, your appearance for the plaintiff in this matter.
Yes, Your Honor, I am present here today. I am Felicia Lipscomb, the plaintiff on this matter.
All right, do I have counsel on this matter?
I'm sorry, I do not have.
Stop. Do I have Clay Miller or counsel for Detroit Legal Group?
Clay Miller is here, PA 6291. My supervisor, Attorney Ryan Hill, he'll be handling this with me. He's just in another court right now, so I'm here for this hearing.
All right, via Zoom. So that's what we're here for on the motion to reopen the case. I granted the motion to reopen the case on the original complaint. Counsel, talk to me. Tell me what the issues are as you see them at this point, sir.
Well, I guess first of all, Judge, this stems out of an alleged representation. And so I think the issue is just she wants money back, and we made her an offer for money back, which she declined. And so I think we're just basically here. It's kind of a numbers game at this point.
All right. So what amount of money was paid to the firm, or to yourself, whatever, in regards to representation of this man?
$2,500, I believe, Judge.
All right. All right. So that is the measure of damages, ma'am. The maximum damages in this matter is $2,500. Tell me what you're asking of the court, ma'am.
Actually, Your Honor, I have a problem with the defendant not being found in default because the defendant did not answer to my filings initially, and he did not answer to the judgment, which he had 21 days to do so. So the defendant failing to do both, the defendant should be found in default of the court order.
That's inaccurate, and that's not what's going to happen here. And if you address yourself to my question, regarding what are you asking the court to do, given that I've reopened the matter at this time.
Okay, Your Honor, and in response to your question today, I do find that $25 is more than fair. I paid to, well, we're going to begin with the $25 that I paid to Mr. Miller, to his firm. The $25 was for, I'm sorry.
Stop, you keep saying the $25 I paid.
I'm sorry, 2,500. I'm sorry, it was 2,500. I apologize. So it was, yes, sir. So it was 2,500. I paid to the firm to represent my daughter. It was on a juvenile case arising out of juvenile court on East 4th Street. I have an 18-year-old that suffers from severe mental health illnesses, and I filed an incorrigibility so that she could not continue to put herself in harm's way. And there was a couple other issues with the case. Mr. Miller, I did ask if he handled juvenile cases, and Mr. Miller claimed that he did. Mr. Miller had one court hearing that he showed up for. At the time, he started to say to me that he didn't know what was going on. He waited to get to court. He didn't know what was going on. He didn't know what was happening. He made a contact phone call to Mr. Ryan, whom is his supervisor, and he started receiving information from him. I actually recorded the entire conversation. And I stated to him, you stated that you handle juvenile cases. I see that you do not. He did not appear for any other court hearing but that one. I had no choice due to his ineffective assistance to handle this case. I had no other option but to fire Mr. Miller. I requested of the $2,500, the entire $2,500 back, because I had to hire another attorney, and I paid out, as you can see in my packet of evidentiary evidence, I had to pay out a sum of $1,500 to another attorney that took on a case and got resolution to my daughter's juvenile case. So Mr. Miller's firm is owing me not only $2,500, but he's also owing $1,500 for the representation by another attorney that took on the case. And in addition to that, Your Honor, I am.
Let me stop you right there. You know, that's almost crazy. You already know that that the fact that you hired another lawyer is between you and that lawyer. You hired them to do a service for you. That's not an issue in this case. You can't you can't hire somebody else to do the work and pay them to do it and then say, give me all my money back and then pay me for a lawyer that I hired to do the work. No, that's nonsense. All right. So I wanted to stop you there, because you can't. There's no basis for recovery under those circumstances whatsoever. So we don't even need to talk about that part, because you can't recover that. You might be entitled to recover the money that you paid to Mr. Miller. That's the issue that's here today. Whether you paid somebody else to do something, that's up to you to pay them to do that. If you fired somebody, perhaps you're entitled to some or all of your money back. But if you hire somebody else, that's a new contract. You enter into a new contract with somebody else. You don't get to say, give me my money back and then pay me for the lawyer that I paid to do the work. You can't do it that way. All right, let me hear from Mr. Miller, sir. Go ahead.
Your Honor, how much would you like me to explain? Because I have some things I would like to respond to what she said, but if today's not the time and place for that, I can save it.
It's really not a trial date, but I'm trying to drill down on this to see where the circumstances. Number one, if a lawyer made an appearance, there is a charge that is going to be associated with that lawyer making an appearance. Secondly, if the lawyer has given any advice and consent, spent any time talking about the case, then appearing, then the lawyer is entitled to a reasonable amount of services rendered in that regard. Whether or not the plaintiff is entirely pleased, satisfied, etc., with the services are done, then she's not going to be able to get all her money back when someone showed up, when someone talked with her and gave her some information. She's not going to be able to get all her money back under those circumstances. The parties could agree to return all of the money, but she's not going to be able to get all the money back under those circumstances. So, you know, if this is a situation where the plaintiff dropped off $2,500, nobody showed up for court, nobody took any action on her case whatsoever, then she's entitled to all of her money back.
I would agree with that.
If there's any action taken, she can't get all of her money back. But if she doesn't get the end result, she decides that I don't want you to do anything further, then the bill stops there. She's entitled to whatever the reasonable amount of the bill that remains, because she, even if counsel wanted to continue, if Ms. Lipscomb says, I don't want you to continue, I don't want you to do another thing on the case, that's when the billing stops. It stops here. So she's entitled to some of her money back because it didn't go all the way. All right. So I don't know what the parties have been discussing. Neither do I want them to talk about what they've been discussing in this case. Where are you talking about a $2,500 case? Obviously, Ms. Lipscomb has also had to litigate the matter, so it's probably about $150 in court costs has been generated, or so, somewhere in that neighborhood, maybe as much as $200. So if you say that this is a case about $2,700, and I'm doing that off the top of my head, I'm not saying that that's what it is. If you say that this is a case about $2,700, and a lawyer shows up to court and has some conversation, that amount of effort is worth somewhere between $500 and $700. That's what this case is about.
I agree.
Oh,
I actually agree with that, Your Honor.
Judge,
sir, Mr. Miller, I'm listening to you now. I heard you, Ms.
Okay.
Mr. Miller.
So, Judge, what happened was Ms. Lipscomb came to our firm about this situation she's talking about. I want to clarify another point. I was retained to represent Ms. Lipscomb, not her daughter. It was an incorrigibility matter, and the issue at the hearing that I was hired to go to was a show cause hearing because Ms. Lipscomb was ordered by the court to go pick up her daughter from the facility. She refused to do that, and so there was a show cause hearing. That's when her and I became acquainted and began discussing this matter. So she came into I sat on the phone with her for the first time, and I didn't even bill her for this, for multiple hours on the phone going through everything. This was at late in the day before she hired us. The court hearing was 2 days away at that point, or the next day. It was the next day at that point. Ms. Lipscomb came into our office that morning around 9:30 and stayed until about 12:30. At that point, I had to let her know, listen, we got a hearing in an hour. We got to go. So we went to lunch. I showed up at the hearing, which was several hours long. Ms. Lipscomb alleges that I didn't know what I was doing. I was calling Ryan because I didn't know what was happening. The actual reason I was calling Ryan is because upon showing up at the hearing, Judge, there were a lot more issues than I was made aware of. The daughter was in a facility which she was supposed to be picked up from. Ms. Lipscomb refused to do it, and the facility she was at was about to close, like permanently close. So there were some practical issues about, okay, if we're not going to get her, where's she going to go in the meantime? They didn't want to send her to the Detroit Detention Center for juveniles because there's a lot, I'm not sure exactly, but there were some bad things going on there. It wasn't the best place for her. So they really wanted to find a new place for her. And so that is partially why I was calling Ryan to figure out what should I do, in the sense that I was trying to represent Miss Lipscomb, who did not want to go pick up her daughter. So I didn't want to have her have to do that, right? Ultimately, at the end of it all, because we were retained so quickly before, or so shortly before the hearing, I was essentially going to seek an adjournment at the hearing. We went there, we were going to get everything in order and adjourn the hearing so we could hold the show cause with me being properly prepared. And it was at that point I realized and discovered all these other issues with the practicality in terms of the facility closing. There's nowhere to send Miss Lipscomb's daughter. And so that is where the confusion was. It wasn't anything to do with the actual case and representing Miss Lipscomb. It was a practical matter in terms of all these facilities were closing, and we had to figure out where the daughter should be in the meantime. So,
so Your Honor, I would like to respond to that, if I may.
No, let me talk. Mr. Miller, I get it. Listen, lawyers consult with other lawyers all the time in areas that they may be competent, in areas that they may not be 100% competent, in areas that they may need insight, wisdom. Listen, the thing for a lawyer to do if an issue comes up that they're not sure about is to become competent on that issue. And one of the ways that they do that is by calling other lawyers, calling a lawyer that's in their firm to say, hey, this is the situation that's being presented, so on and so forth. Otherwise, it's not for them to just be there and say, well, I'm not sure, but I'm not even going to ask any questions. They're trying to figure out what they need to do. That's not really what this case is about. That's not what this case is about at all. The fact of the matter is that both Mr. Miller and Ms. Lipscomb found out some stuff about this case when they got to court that day that neither party anticipated in this case. This sounds like something that was blowing up more and more and more. Why? Because it has to do with a minor who has some challenges, and Ms. Lipscomb trying to position herself as best as she possibly could. I get it. What the issue comes down to is that this is an attorney-client relationship that went for a number of different reasons. One is because on both sides, neither party expected and anticipated some of what occurred at court. I get that. What it comes down to here is it comes down to a situation where you got like about $2,700 on the table here. Look, I mean, you guys can find out. You can have a try. I'm giving you my sense about what the numbers kind of look like. Those numbers can go anywhere, in my view, somewhere between $1,700 and $2,700 is where this case kind of resolves itself. It's a situation that turned out bad for the lawyer involved. It turned out badly for Ms. Lipscomb, and that's it. I mean, sometimes this happens. It's a situation that did not work out. And the fallout is, how do we resolve this? And I'm telling you, of course, based on 31 years of experience as a judge, and then several years as a practitioner, and I've had these kind of situations before. It's a bad situation for both sides. And the question is, how do you find a way to resolve? Well, one of the ways to resolve it was that Ms. Lipscomb went and hired somebody else. She didn't want to continue with the service, so she stopped the billing because she went to somebody else. That was a better way of doing it, rather than just go on and on and on, and then there's a bigger fight about what the number is involved. So the wisdom was that whether Mr. Miller, did a great job or was trying to put together a great job, the relationship fell apart. And a wise thing for Ms. Lipscomb to have done was to go and hire somebody else that she was more comfortable with, and to stop the tab. And the whole question here is, where does the tab stop? And I'm telling you, I'm not ordering that at this point, but I'm telling you that this tab stopped somewhere between about $1,700 and about $2,700 because of the court costs in this matter. So 100 here or 100 there, I think the parties need to find a way to resolve this and move on about their business. It just didn't work out. And this doesn't make, listen, if I decided this was bad, terrible, or something, I'd tell you that. I mean, I spent a lifetime of doing that. Just like Ms. Lipscomb, when she was telling me that, well, they got to pay me because I had to pay another lawyer. No, they don't. I mean, it's just, I get it how people think that sometimes. No, they don't get that. What the dispute between these parties is about the attorney fee, or the agreement that the parties reached, and the fact that Ms. Lipscomb decided to fire her lawyer, and she wants all or a portion of her money back. I don't believe that she's entitled to all of it back, but she's entitled to some of her money back. And the parties need to find a way to get that done. I'll set it over for trial if you need to do that. But again, I've taken a look at some of the stuff on the surface. I hear more details. Maybe some things change. But what I've heard here, the parties are not really in disagreement here. Ms. Lipscomb tells me some things from her perspective. That is that she thought that Mr. Miller didn't know what he was doing. When I hear from Mr. Miller, he says, I discovered a set of circumstances that are there that require that I consult with an attorney in my office. That's what lawyers do. That's what they do. That's what they do. So I understand how that could look on one side or the other. At the end of the day, that doesn't even become an issue. The issue becomes, and Ms. Lipscomb said, I don't want to go forward with these lawyers anymore. I'm going to go hire me another lawyer. I want the tab to stop. Give me my all or some of my money back. That's what this case is. And that's, you either figure it out or the court will make a decision on it.
And Your Honor, if you don't mind, I would like to respond. I am in the education and also the nursing profession. And what I do not want is my good name to be tarnished as a mother. And on the record, Mr. Miller made comment that I refused to pick up my daughter. And that is one reason. And yes, I was ordered. I am a very honest person. I was ordered to pick up my mental ill daughter. My daughter was not able to come home, Your Honor, because the facility called Wolverine, which that facility was shut down because of abuse against my daughter and a couple of other children. That facility was shut down. It was, I believe, on the news and everything on April the 7th. My daughter was beaten. My daughter's hair was snatched out. My daughter was placed in a room naked without any clothing. She was taking off all of her medications. My daughter attempted suicide on multiple occasions. There was a lot that was going on, and I requested that my daughter be transferred from the Wolverine facility to Vista Maria.
That's not what it was.
I'm sorry, excuse me. I have documentation, sir, to support.
Let me stop you. You guys can argue about it. I cut you off and I cut him off too. You guys talk about that, have it over lunch. No, that's not what this case is about. And no, and Mr. Lipcomb, there is nothing about your reputation as being a human situation. This is a dispute that parties have, and reasonable minds see things different. Excuse me. Reasonable, ma'am, you're still talking. I can't hear you because I put you on mute. I don't want you talking uselessly because I put you on mute. My point is this. Listen, I know that these are highly sensitive issues, et cetera, and I know that the parties see things differently about this. And I have nothing here to impugn the character of the various parties that are here. I know that the moment that Ms. Lipscomb told me that this was involving a young lady that has struggles and then counsel told me that this was a young lady involved that was in a placement facility and so on and so on. That's a lot of stuff. That's a whole lot. And listen, unfortunately, this case is not about any of that. This case is not about any of that. Why? Because at some point, Ms. Lipscomb made a decision that these lawyers are fired. I don't want to go forward with these lawyers. That's it. That's over. All the other talk, and I appreciate Ms. Lipscomb having a background as in education, et cetera. And I know that if somebody filed a complaint against you in some formal setting, that a record could be made, and that's not what's happening here. This is a court-related dispute, and none of that impacts on anybody's professional credentials or anything like that. This is for Ms. Lipcomb, a family-related matter. For Mr. Miller, a legally related matter, and the parties are going to have some disputes about what their view about those things are. Fortunately, that's not particularly relevant because this is just a contract dispute where the parties had a contract to do something. One side said, "Hey, I want to end the contract here. Don't do anything else for me. Stop right here. Let's move on. You're okay and I go my way." The other stuff is just not, it's not relevant to this dispute. It's just not. All right. I let both of you have a little bit of wind on it. I let Mr. Miller say something. I let Ms. Lipcomb say something. It's really not relevant to this underlying case. It really isn't. I told you what the numbers look like. It's difficult to step into those kind of things at times. Sometimes if you have a fee agreement and it lays out in minute detail every part of what is to happen, and the fee agreement will govern how things are, how the outcome is if the contract is canceled. But I haven't heard anything laying out any particular minute details of the agreement. If you want to do that, I'll hear the context of a trial. Otherwise, what seems to make more sense to me is what I've already suggested to you guys. If you want to talk about the underlying facts and the disputes of whether this happened or that happened, you're never going to be able to resolve a case that really is about a contract dispute. No. One person says, "I don't want to go forward on this contract." and I hire somebody else to go about my business, give me my money back. Let the court decide basically how much of my money I should get back. Reasonable parties should be figure that out. It didn't turn out well. It's a mess on both sides. Right?
Judge, I just want to say one thing, and it's relevant, I promise. I kept track of all my hours, doing everything from the conversations to my time at court and everything. It totaled to a little over $2,000.
No, that's not, no, I don't agree with that.
And
you know we don't do it that way, Ms. Lipton. You know we don't do it that way. All right, go ahead. Finish saying what you're saying.
I just wanted to say, Judge, I kept track of my hours. They're around 2,000. We offered her more than that initially when all this came to a head. We made an offer of more than like what we had done on the case. And she refused and denied it. And so I guess that's why we're here. So I just want to
Your Honor,
let the court know that I have a record of my hours and things I was doing on the case and everything like that. And we did make an offer, which was generous and more than that. So just so
I want to state that I kept track of everything that he did, which was nothing. I have emails that supports that I provided all of the documentations that was needed by email. He made no copies. He made no phone calls. He did nothing. I provided everything by way of email. I came into the office and gave a second packet of everything that I provided by email. I asked the gentleman to call CPS so that he could know that CPS did not have a case against me as a negligent parent and that I had grounds, head office of Lansing, I had grounds for not picking up my child because I gave evidence to Lansing CPS to show that I was not a negligent parent, that my child was not in her right state of mind. He refused to even do that. I then asked him if he could make a phone call also to the it was, I think, the social worker that was there at Wolverine to make a contact with Wolverine. He refused to do that. Every single thing that I asked this gentleman to do, he refused. He got to court. He didn't know what he was doing. He made a phone call. He said to me, I don't know what to do. I'm going to ask for an adjournment. I need to call Ryan. I said, but that's not what you told me. I explained everything. And in my emails, as you can see, and I provided that in my packet, I provided every single thing that he needed to represent this case. He took on this case over the weekend. He says, I need you to get everything to me between Thursday and Friday. I did that, Your Honor. That following week was the court hearing. We got inside of his office. I recorded everything. Everything is recorded. How he pretty much flipped the script on me and said, I don't really know what to do, but we can get to court. He even stated that in the actual office, like he was confused. He flipped the script on me like I was a negligent parent. I didn't know what it was that I was doing as a parent. I said, are you turning on me now as my attorney? I was like, I'm an excellent parent. This is not about me being a horrible parent. I'm a good parent. I have done nothing wrong, but make sure that my child is safe and my child cannot put herself in harm's way and that this facility cannot continue to abuse my daughter. This gentleman did nothing. I supplied everything to him through email. So what did he have to do? He did nothing. He didn't go obtain records. He didn't go obtain anything. We had a conversation in his office because he told me to come in and make the payment. He started saying, and I recorded I have a recording. So if this go to trial, I can assure you, Your Honor, that he is going to be found as an attorney that ineffectively assisted my case, my daughter's case. That is actually what this recording, if you would like the recording, I can put it on flash drive and actually get it to you. That would be the recording in his office from point A to point Z, and the recording that my daughter recorded while I was speaking with him at the courtroom. So if he want to take this to trial, I can guarantee you he's going to be found in contempt for falsifying on the record. So we can do that if he would like. That's not a problem because I covered myself. And one thing I'm not, Mr. Miller, is a liar. I'm a very honest person. And I told you also, I recorded everything. And you know, Mr. Ryan, and I told Mr. Ryan that too. But Mr. Ryan said, oh, and we recorded you as well. I said, come on, let's bring it on. Let's get this to court because this is wrong as to how my case went on. You was not fully knowledgeable as to how to represent a juvenile case. You didn't know what you were doing, and I canceled you, and you had a problem with that. Hired another attorney, paid $1,500, and you know what he did? He got me resolution. My child was transported to Vista Maria from that abusive facility that was closed down April the 7th. Got resolution, good resolution. My daughter is now in her right mind. They put her back on her meds. she is doing good. I'm an excellent parent. And one thing I'm not going to do is tarnish my good name. I'm a good person, I'm a good mother, and I'm an honest person. You want to take this to trial? Let's do that. Because in the court of law, I am able to present evidence. And one of the pieces of evidence is that recording, 2 recordings that I have that support that you did not do what it is that you was supposed to do by I or my daughter. And I am prepared, Your Honor, today, so we can just move forward. I have a lot going on. I'm working 3 jobs, Your Honor. I'm trying to get back in school to
Stop. I've allowed the parties to go on and on basically about stuff
sir.
that is really not about anything. I've already told you what this case is about. Moreover, and I'll say to Ms. Lipscomb, she talked about sending documents to lawyers and being in the lawyer's office and talking to lawyers. Even if you ultimately disagree with their level of service, those are billable hours. That's the problem here. Is that you're creating billable hours. And you talk about I talked to the lawyer about this. I disagree with them on this and so on. You're still creating billable hours. You're a professional as well, and you know that there are times that people totally disagree with the service that you provide, totally disagree with things that you call, and totally disagree with the approach that you take. That still does not diminish them. I hope that you're not saying that people never disagree with you. But anyway, the fact of the matter is that you get paid for your services even when there are people who disagree with the manner in which you conduct those services. That is part of the issue that is involved here. Go to trial, all of that, of course, will become a part of the equation. But the bottom line is going to be here that you hired somebody to perform services. They ventured in the direction of performing services, and then there was disagreement. Now my notion about that, my thoughts about that is that the services that were performed means that you should get a refund somewhere in the nature of, I said somewhere between $1,700 and the total amount. Counsel seems to believe that they earned $2,000 of the fee for services. If you want to go to trial, I think you're gonna have a mountain to prove that. But if that's what you want to do, then I'll set the matter for trial. I believe that Mr. Hill is from your offices here.
No, that's not Mr. Hill. That's a different Hill.
So my inclination was to send the 2 of you to a breakout room to solve this case with the numbers that I pointed out. You don't think you can solve the case? I'll just set it up and have a hearing date on it. I've heard most of what I need to hear. I'm not going to let any of this go appeal. I don't need to hear tape recordings and all of that. I don't need to hear any of that. None of that's going to be relevant in this case. What's relevant in this case is how much time was spent in an effort to try to resolve this, number one. And number two, whether or not the client received the outcome that she wanted to receive, although the outcome that received may have been something very different than what she anticipated when hiring Mr. Miller. And so, again, on both sides, there is some critical, if you will, disagreement as to which way this should have gone. But that disagreement may be one side or the other here. This is just a contract that was drawn up, and a contract that one party or both were not pleased with, and one person decided to end it and went on to hire somebody else. The most reasonable thing that was done in this case was to terminate the contract. That was the most reasonable thing to be done, because that somehow prevented this from becoming something that was worse. It's not unreasonable for a lawyer to come to court, discover the various things that are going on, and say, what's needed here is for an adjournment to another day to work out the details of this. That's not unreasonable. But if that's something that Ms. Lipscomb disagreed with and said that this should be resolved on this particular day, then that's a reasonable position for her to take too. She's not a lawyer, but that's a reasonable position to take. That's why she decided to terminate the contract and wanted to move in a different direction. So if you guys want to talk about this in the breakout room, tell me something so you can get this resolved.
Yes, sir.
Lipscomb already told me that she was in a posture to try and reach a resolution in this matter if the If Mr. Miller wants to do the same, then you can talk about it. If not, I'll set it up for trial now. The next date you come out, I'll hear it and decide this case. Mr. Miller?
We'd be okay with setting it for trial, Judge. I guess the one remaining issue is that we would like to ask for costs in this matter, $500 for having to file an objection, having to show up today. And it's really all because of Ms. Lipscomb's failure to timely proceed with the case.
Your Honor, I don't agree with
We have to show up here to take time out of our day to basically start this over at square one when this was filed in June. It's really causing issues for the firm, setting us back.
Actually, Your Honor, I disagree with that because the attorney had more than enough time to answer to my filings. They had more than enough time to pay out on the judgment, and they did not. And actually setting it up for trial, and I have work. I have a lot going on. I was just recently in a car accident. My daughter is getting PT and OT physical therapy along with trying to work 2 and 3 jobs.
Again, Judge, this isn't relevant. I'm sorry, but come on. This isn't relevant.
Let me stop both of you. I don't like people talking over people and all that. Because of the sensitivities involved in this case, I've allowed both sides to talk. Most of what you're talking about, it's totally irrelevant. Don't mean anything. It personally means stuff because people are caring for kids, lawyers are caring for their firm and all of that. But in this case, it doesn't mean anything. It just doesn't. And the whole notion of $500 in cost in this case, that's counsel, that's borderline lunacy for you to even make such a request in this kind of case. And so the motion is denied. I'll set it up for trial. Come back and let me hear it. And I'll allow you to pour it out on the table, because if there's something here that looks like some less than proper practice in this area, then I'm going to drill down on that too, because this makes no sense. This is a window into how you operate in the public's eye as it relates to dealing with this matter. There's a reasonable way to talk. You can disagree with that, but come on back and let's try. Let me hear all angles of it so I can make a decision, because it sounds like maybe there's more going on here than what I've been able to see. So I really want to hear that. So let me set a trial date on this.
Thank you, Your Honor. Thank you so much.
All right, so let me set this. Let's see if I can get to this before. Can I do this on the 20th of December?
Yes.
All right. So December 20th, 12/20/23, and I'm setting this at 10 o'clock a.m. Come back and let me try this case.
Thank you, Your Honor.
Thank you.
That's Zoom,
you.
Judge?
I'm sorry. Yeah,
Will
you
that
got
be
the
Zoom
trial.
again?
Same Zoom. Yeah.
Okay.
Yeah. Come back into the Zoom. Thank you. Good day to you.
Thank you so much, Your Honor.
Thank you, Judge.
All comments, viewpoints, interpretations, and insights expressed in this video are for education and entertainment purposes. All individuals featured in the video are to be presumed innocent until proven guilty in a court of law. Please do not attempt to contact, locate, or engage with any individuals featured in the video.